Hello and welcome to this video lecture, which is part of Unit 2 of our program on media laws. I'm Ajju John, and in this video lecture, let us discuss anonymity of sources and their protection under law. Now, journalists have a variety of sources. They could be press releases issued by organizations, press conferences where someone from an organization addresses the gathered press, or it could be interviews with people. Now, whatever be the case, sometimes a source chooses to remain anonymous. The source wants to disseminate certain information to the wider public, but does not want the wider public to know that they were the source of the information contained in a news report. The reason a source chooses to remain anonymous is usually because of the sensitive nature of the information conveyed to the journalist, such as corruption or misgovernance or organized crime. Remember what we read in Unit 1. One of the philosophical justifications for the freedom of speech and expression in a democracy is the role the press plays in communicating the information that enables people to participate more effectively in the affairs of the state. This means that such sensitive subjects are exactly the kind of material that the press should be able to publish fearlessly about, and they would not be able to fulfill that role without agreeing to keep the details of the source confidential. Media organizations do not ordinarily publish or broadcast anything, a news story, which rests exclusively on an interview that a journalist has conducted with an anonymous source. This is because anonymous sources threaten the credibility of a story. A viewer or a reader cannot independently verify the truth behind a particular story. In spite of these misgivings, the history of the press is replete with instances where a story broke only because a source spoke to a journalist on the condition of anonymity. The Pentagon Papers, a top secret study of the American war efforts in Vietnam, was leaked to the New York Times under a pledge of confidentiality. A source known only as Deep Throat and later identified as the man in the picture, Mark Felt, an FBI agent, leaked information to the Washington Post about the involvement of US President Nixon's administration in what came to be known as the Watergate scandal. Documents related to the investigation into allegations about corruption in the purchase of Bofors guns was provided to the Hindu by a Swedish police officer who chose to remain anonymous. The fact that star Australian cricketers had received money from a bookmaker only became public following a tip-off from an anonymous source. The Indian public still don't know who leaked the Neera Radia tapes to Open magazine. WikiLeaks, an organization that publishes news leaks and secret information from anonymous sources, published a set of 400,000 documents about the Iraq War and later collaborated with news organizations to publish an archive of US diplomatic cables. Allegations of sexual harassment against former judge of the Supreme Court, A.K. Ganguly, first appeared in an anonymous blog. How confidently can a journalist or a media organization promise anonymity to a source? Are there situations where the state or any other body can compel a journalist to disclose the identity of his or her source? This brings us to the three questions that we will briefly answer in this video. Is there a right to protect the source of a story? Who can claim such a right? And what are the exceptions to this right? To see if such a right exists at all, most authorities rely to begin with on the inclusive definition of the right to freedom of speech and expression in Article 19, Clause 2 of the ICCPR. The right includes the freedom to seek, receive, and impart information and ideas of all kinds. In 2005, the UN Commission on Human Rights stressed the need to ensure greater protection for journalistic sources. In 2004, the ICTY held that if journalists are compelled to produce evidence too frequently and too easily, it could hinder their ability to gather and report the news. A body of cases from the European Court of Human Rights has also developed under Article 10 of the ECHR, which provides for the freedom to hold opinions and to receive and impart information and ideas. The first and most important case is Goodwin versus UK. A journalist was asked to disclose the source of his information about a company's confidential corporate plan. The court held that without protection, sources may be deterred from assisting the press in informing the public on matters of public interest, and the public watchdog role of the press may be undermined. Orders to disclose sources reduce the flow of information to the detriment of democracy and are only justifiable in very exceptional cases. In Voskuil versus the Netherlands, a journalist who had written an article on a criminal investigation into arms trafficking was detained to compel him to disclose his source. The court held that there had been a violation of Article 10 of the European Convention on Human Rights, finding that the government's interest in knowing the identity of the journalist's source is not sufficient to override the journalist's interest in concealing it. In Nagla versus Latvia, police searched the home of a journalist who had broadcast about an information leak from the database of the State Revenue Service and seized data storage devices. The court held that there had been a violation of Article 10. The right of a journalist to not disclose sources is not a privilege dependent on the lawfulness of their sources, but an intrinsic part of the right to information. In the United States, the 1972 judgment of the United States Supreme Court in Brandsburg versus Hayes has been very important in establishing a right to the protection of journalistic sources. While the majority opinion held that the First Amendment, about which we learnt in the previous unit, does not protect a journalist who has witnessed criminal activity from revealing his or her information to a grand jury, Justice Potter Stewart's dissent said that the court should weigh the First Amendment rights of reporters against the subpoenaing party's need for disclosure. He asked courts to consider, firstly, whether the information is relevant and material to the party's case. Secondly, whether there is an overriding interest in obtaining the information. And thirdly, whether the information could be obtained from any other source. On this limited point, Justice Stewart received a lot of support from the other judges on the bench. In some states of the United States, journalists are protected, to varying degrees, against the compelled production of confidential and unpublished information by a statute. These laws are known as shield laws, and Justice Stewart's dissent forms the basis for many of them. In the United Kingdom, the common law did not grant journalists an absolute right to protect the identity of their sources. The court had the discretion to decide whether or not to compel journalists to reveal their sources. This position was reinforced in Section 10 of the UK's Contempt of Courts Act, under which a court can compel a person responsible for a publication to disclose the source of the information in that publication only if it is satisfied that the disclosure is necessary in the interests of justice or national security or for the prevention of disorder or crime. These broadly worded phrases, as we will see later in this video, limit the right to protection of journalistic sources. In India, the Indian Evidence Act privileges some kinds of information. For example, no person can be compelled to give evidence about any communication made to their spouse during their marriage. Similarly, broadly speaking, no lawyer can be compelled to give evidence about any communication received from a client during the course of their professional engagement as a lawyer by that client. This privilege acts as an exception to the rule that any competent person can be compelled to provide evidence. Unlike these types of communication, the communication between a journalist and his source of information is not privileged in India's evidence law. This means that a court can always compel a journalist to reveal the source of a story. In the case of proceedings before the Press Council of India, Section 15 Clause 2 of the Press Council of India Act limits the evidence-taking powers of the self-regulatory body. The Press Council, however, is generally considered a toothless body that cannot impose any serious punishment on the press. So it cannot be said that Section 15 Clause 2 establishes a general right to the protection of journalistic sources. In Jay Prakash Agarwal versus Bishambar Dutt, a 1986 case before the Delhi High Court, the court directed the reporters of Jansata and Punjab Kesari to disclose their sources for a story alleging that a judicial verdict in an election petition had been fixed. Now that we know that a right to the protection of journalistic sources has been recognized under the European Convention on Human Rights and exists to varying degrees in England and in the United States of America, let us look at who can exercise such a right in these jurisdictions. A wider class of people may exercise the right in Europe compared to the United States and England. In Europe, a wide class of persons, including traditional journalists, can exercise the right flowing from Article 10 of the European Convention on Human Rights. Even people like activists and others who have played a role in bringing information to the public have the right to protect their sources. In the United States, shield laws mostly only protect traditional journalists. In England, only persons responsible for a publication may exercise the limited right under the Contempt of Courts Act. The right, as I have mentioned, does not even exist in India. We have studied whether the right to the protection of journalistic sources exists. We've also looked at who can exercise such a right. Now let us look at situations which are exceptions to this right. Let us look at situations where the law can legitimately compel a journalist or another person to disclose the source of information. In Europe, there has to be an overriding public interest in the disclosure, and the court has to balance the interest in disclosure against the harm that would be caused by it. In the United States also, a court has to balance a journalist's First Amendment rights against the interest in the disclosure. In doing so, the court has to ask itself three questions. Is the information relevant to the issue before the court? Can it be obtained by other means? Is there a compelling interest in the information? In England, a court can compel a journalist to disclose his source in the interest of justice, national security, or for the prevention of disorder or crime. In India, a court can always compel the disclosure of a source. And with that, we come to the end of this video lecture. We have surveyed the legal systems of India, Europe, England, and the United States to check whether there exists a right to the protection of journalistic sources. We found that the right does not exist in India. The right exists to varying degrees in Europe, United States, and America. We found out who can exercise such a right in these jurisdictions and under what circumstances such a right may be legitimately restricted. Thank you for watching. You should do the practice exercises before we move on to the next unit on defamation.